Good morning, ladies and gentlemen. My name is Kenan Hajimosic. I'm Senior Manager in ECAS, and it gives me great pleasure to moderate our first panel today, Freedom of Movement Challenges Today. We have gathered for you an expert panel of speakers who I will introduce. We have with us Mrs. Genta, who has a background in European law and has worked for the European Parliament for the past 11 years. First as an administrator of a parliamentary research unit and an administrator of the Secretariat on Women's Rights and Gender Equality Committee. Then, for the last 2 years, for the Secretariat of the Committee on Petitions. She has recently been in charge of organizing a hearing on the obstacles of EU citizens' freedom to move and work within the internal market, based on the petitions received by the European Parliament, and a fact-finding visit to Sweden on the issue of the personal identification number. We also have with us today Mrs. Mary Denninghaus, who is a policy officer at the European Disability Forum and responsible for EDF's work on mobility and transport. Her work includes advocacy on EU transport and consumer policy, as well as overall coordinating responsibility for EDF's campaign on European Accessibility Act and EDF's long-standing Freedom of Movement campaign. We also have with us Antoine Fobe, who has been advising citizens as a freelance consultant in the European Your Europe Advice Service and its predecessor since 1996. As a member of the Your Europe Advice management team within ECAS, he has drafted and participated in the feedback reports to the European Commission on the problems experienced by citizens in the exercise of their European rights. Previously, he was employed by ECAS as a legal director, and before that, by the European Commission in the Info 92 information tool on the internal market and the social dimension. In 2002, he contributed to a guide for EU law practitioners on freedom of movement of persons. In 1995, he authored an ECAS guide, 50 questions and answers about your rights in Europe. We also have with us Dr. Anthony Valk, who has been advising on EU residents' rights for over 10 years. He directs the operations of the EU Rights Clinic, and the first law clinic that specializes in EU law, which was set up by ECAS in collaboration with the University of Kent in Brussels. He's a visiting lecturer at Kent and teaches course on EU migration law and EU advocacy. He's also adjunct professor of law at Vesalius College in Brussels, where he teaches EU law related to the single market. He's a qualified solicitor in England, and he's also a member of the Brussels and Palermo bars. He received his PhD in comparative law from the University of Palermo and holds a degree in English and French law, as well as a postgraduate qualification in EU law. And, of course, we also have Nicola Milanese, who is the founder of the European Alternatives, a civil society organization promoting democracy, equality, and culture beyond the nation state, active throughout Europe over the last 10 years. He has extensive experience of linking grassroots civic actors with institutional processes through campaigning, citizens' consultations, leading Europe Citizens Initiatives, lobbying and organizing forums and festivals, activities that have received prizes from the European Parliament, European Economic and Social Committee, German Federal Agency for Civic Education, and the Charlemagne Foundation. He is part of the elected steering committee of Civil Society Europe. The order of the interventions will largely follow the one that is indicated in the agenda. I would just like to ask Mrs. Denninghaus to speak in third place, and then we will follow the order which is indicated in the agenda. Let's start with Mr. Antoine Fobe, who will present the Your Europe Advice annual trends. Antoine, the floor is yours.
First of all, I would like to thank ECAS for their kind invitation to speak. I've been asked to bring the Your Europe Advice experience of difficulties encountered by citizens in the exercise of free movement rights. I'll say a few words about Your Europe Advice first, although you have a description in your documentation file. Your Europe Advice is a service currently provided by ECAS, European Citizens Action Service, in a contract with the European Commission DG GROW, to inform citizens about their rights and also advise them on how to enforce them, possibly. Your Europe Advice also produces periodical feedback reports to the Commission to tell about the stories we hear from the citizens and point out problem areas, areas of improvement, etc. As a starting point, I would like to point out a statistical trend observed by your Europe Advice, and which is actually on the screen there for you to see, and it's also in your files in case it is too small for you to see on the screen. There is a marked increase of problems related to entry and residence in another EU country. These account respectively for 19% and 17% of the questions citizens contact us about. These two issues come second and third, right after social security, 24% of the issues. Well, social security has always been a very popular issue. It is more surprising to find the entry and residence so high today, whereas other popular concerns fall far behind. For instance, work, car-related issues, taxes, consumer issues, which run between 8 and 6%. So really, we can say that entry and residence are major issues. Entry, in particular, it has been a constantly growing share of the questions we are contacted about since 2011. Now, this trend, the reason why I start by exposing this trend is that it is an alarming statistic. If the citizens' right of entry and residence is problematic, talking about all the other obstacles that have to do about integrating and participating in the society of another country become rather marginal. The very first point is being able to get there and to be there lawfully with a recognized right to stay. And we discussed this with ECAS, with Asia Kavrakova, the ECAS director in particular. I want to quote her here. Basically, it means we are back to the basics of ensuring free movement of people. And it's sad to have to say this in 2017. Of course, I should specify that your Europe Advice is contacted not only to complain, we also get simply questions which are requests for information about EU law. So the statistics you see there are not all complaints. But if you look into that part of those questions, those submissions that we get that are actually complaints about difficulties, practical difficulties, and infringements, it probably reflects the proportions. And in any case, a significant number of users have issues about infringement of their EU rights. A lot of the problems concerning entry and residence, to describe them, have to do with non-EU family members' rights. So basically the possibility for an EU citizen to enter and reside in another EU country with their non-EU family members. Basically three top issues there. Excessive procedural requirements or delays to obtain a residence card due to, for instance, non-recognition of marriage certificates, excessive language requirements, passports being retained for an excessively long period, which actually blocks people in a given country, without having, while you wait to obtain the residence card as a non-EU family member, you do not have access to employment, whereas that residence card is only supposed to attest of your right, but not to condition it, etc. Another popular, if I may use that expression, problem is failure to respect the visa exemption for non-EU family members. That is, those non-EU family members who carry a residence card attesting of their right to stay with an EU citizen in a member country and wanting to travel to another EU country. If they have that specific residence card delivered to them under EU law, they should not have to obtain a visa. Yet there is still a large degree of ignorance in this rule, which is largely due to the fact that many consular services outsource the visa application procedure to private service providers who are not fully up to speed on the specific rules of EU law. The third problem area is actually the failure to respect, and it connects to the same issue I was describing, the failure to respect the special rules for visa applications that apply to non-EU family members of a mobile EU citizen. That is, that the visa should be granted under an accelerated procedure and free of charge, with limited documentary requirements. We have a lot. We observe a lot of problems in this area. Hard to say if it's ignorance by the services that handle visa applications, or bad will, or we can observe that the problems are there. Now, EU citizens themselves, not only through their non-EU family members, are also directly concerned. And it would be impossible not to mention a recent trend. There was much talk about Brexit already this morning. Of course, after the Brexit referendum result, many UK nationals in the EU 27 countries and EU 27 citizens in the UK are concerned about their acquired rights in their host country. The difficulty is that your Europe advice can only reply in the current legal state of play without being able to anticipate the outcome of the Brexit negotiations. So we are in a gray area for the future. But what we can say, at least, is that, as confirmed by the EU institutions, EU law still applies in full today. The problem there is that in practice we already get a lot of complaints from citizens about drawbacks already today. That is, EU 27 citizens in the UK who have been residing in the country for a very long time and find that it is made very difficult, to say the least, for them to get a residence card attesting of their acquisition of a permanent right of residence. And the same thing is observed also in the EU 27 countries. I work specifically on France, so I can speak for France, but I'm sure it happens in other countries too. You also see that when UK citizens who want to ensure or try to enforce as much as possible their right to stay in France today apply for a permanent residence card, the card they are entitled to because they have resided for at least 5 years in the country, they're told, no, we don't deliver residence cards today. You don't need one, or another pretext could be, well, we're waiting to see what the outcome of the Brexit negotiations is. You get all sorts of explanations, but none is in conformity with the legal state of play. But leaving the special Brexit context aside, there is, and already was in recent years, a trend of what I would call a negative attitude of national administrations. I specify that this here is me speaking, not your Europe advice or ECAS. It is my opinion as someone who has been working in that service, what I feel through the different cases I have observed and dealt with. A negative mood. Let me explain this, and I will describe it through 3 observations that I have made. First of all, I observe a lack of EU spirit. I'll mention the 3 things: lack of EU spirit, lack of communication and cooperation across borders, lack of action to tackle structural problems. So let me start with lack of EU spirit. Initially, your Europe advice mostly addressed questions about EU rights and complaints about difficulties in exercising these rights caused essentially by lack of awareness of administrations. Today, the problem raised by your Europe advice users are more complex and require more in-depth analysis of EU law. This is mostly due to the fact that the administrations involved are more and more aware of the details of EU law. And instead of working in the spirit of EU law, free movement for instance, seem to be looking for possibilities to raise exceptions, derogations, safeguards. I'll give you just one example, but there are many. You probably all are familiar with Directive 2004-38 EC, which is the Free Movement and Residence Directive. That directive brought something which was a very spectacular progress at the moment, the abolition of the formality of residence cards for EU citizens. The idea was to make free movement for them simpler. You don't have to apply for a residence card to show that you are lawfully residing in the country, and you can prove your lawful residence just as the nationals of that host country do. In practice, the fact that you do not have a residence card anymore today is used or appears to be used and applies for social welfare benefits or family benefits, whatever, but residence-based benefits. The administration to show that I have a residence card, a residence permit, or I'm lawfully resident. And often you'll find that the administration is not familiar with the fact that you are not supposed to have a specific document for EU citizens. So, but the administration is very familiar with the rules that in that same directive I mentioned, you need, if you are inactive, in principle, you need to have sufficient resources, health insurance covered to have the right to stay. Let alone, let's ignore the fact that I have acquired a permanent right of residence. Let's suppose that I've been resident in the host country only for two years. It makes it very difficult. Basically, whereas the directive wanted to make the burden of proof, to reduce the problem of burden of proof, it actually created a problem. And the problem is not due to the directive itself. It's due to the way that the national administrations use the directive, the exceptions in the directive, the difficulties in the directive, the safeguards in the directive, and not the principle. That was that unless there are reasons to believe you are illegally staying in the country, you should not have to prove it through documentary evidence. Second type of problem, lack of communication and cooperation across borders. Most problems dealt with by Your Europe advice have a cross-border dimension. To be solved, they would require direct communication and cooperation between administrations across borders. Even where the rules of cooperation are carved in EU law, national administrations appear still very reluctant to engage directly with their counterparts in other member states, leaving the concerned citizens in situations where they have to deal with sometimes contradictory positions, and to liaise with services which are distant, whether in their home country or in their country they plan to move to. This is quite obvious to see in the area of social security, where there are very complex and indeed detailed and sophisticated rules of coordination. For instance, Regulation 883/2004 provided for specific forms, e-forms and portable documents, precisely to not only allow citizens to take documentary evidence with them, but also most of the documents which are unknown to the public are for direct communication between administrations. Now in practice, it seems, from what we see, that administrations are not using these forms a lot, and they're simply telling citizens, go and get this document you need to get from that other country and come back to us, please, which creates very huge logistical difficulties for the citizens. So again, a certain lack of goodwill, or at least intention to use the instruments that are there and provided by EU law. A third general problem I observe is a lack of action to tackle structural problems. Many problems have been there and well known for quite some time now, and yet they persist. Just to quote a few examples that are very directly connected to issues of entry and residence: the difficulty to obtain a so-called personal number in Sweden, which creates huge logistical difficulties; the difficulty in Spain to obtain the national identification number for foreigners, which again, think about what I was saying about the absence of residence card. The problems have been reintroduced in another way. The fact that in France they don't give you a registration certificate, so you have no registration certificate, you don't have a residence card. How do you prove that you are resident in the country? Except through very complex procedures. So all situations that end up making the abolition of residence cards not a progress. So member states don't show the willingness, I think, to engage for the respect of their own citizens' EU rights across EU countries. You would expect them to want to be concerned. Just to give you, I would expect my own country, France, to be concerned if I, as a French citizen, experience difficulties in Germany. They might want to think that, well, there are EU rules, we're all in these rules, we have to respect, as a country, I have to respect the rules of German citizens. In France, well, I want reciprocity. It is important that EU law is not about reciprocity, but at least there should at least be respect of EU law in all EU countries. Well, actually, member states seem to take a very passive attitude. You deal with your problem with your host country, and there's no really participation there. Well, I have to mention Solvit. Solvit is a very interesting service. Many of you have probably heard about it, and it is directly connected to your Europe advice. Basically, when your Europe advice observes that there is a clear case of infringement, or possible, as far as we can see, possible situation of infringement of EU law, the logical next step for us is to forward the complaint, or at least advise the citizen to complain to Solvit. Solvit is actually a network of services within the national administrations that is there to help citizens solve problems concretely, rapidly, online, and for free. So it's a noteworthy service. Solvit, the interesting aspect of Solvit is that it builds on peer pressure. So basically, in my example, French national having difficulties in Germany, I would turn to Solvit France, and France, the Solvit French Center, would liaise with the German Solvit Center to ask what the problem is and have their point of view and try to find a solution to the problem. So peer pressure is key here. But the problem, Solvit is not equipped to address the more structural problems which at some point need to be addressed beyond individual complaints. And these structural problems seem to be solved only through time-consuming infringement procedures started by the Commission, with national administrations taking a very passive defensive stand. This leads me to my conclusion. At a time when the EU needs to showcase its concrete added value for citizens, it should be careful not to let the free movement of citizens become just another nice slogan against the reality of returning restrictions and indirect barriers of all types. Implementation of existing rules is essential. Connecting to the title of this conference, Free Movement of Persons in the EU, a Loved and Feared Reality, I would like to end with a provocatory question. How could citizens remain enthusiastic about free movement of persons if member states, through their administrations, do not appear to value it with a sense of awe?